Hello friends, welcome back to IQ Nest. In today's video, we would be discussing about writs, which is a part of Indian Constitution. So before we start, a few words. If you are watching our channel for the first time, please subscribe our channel and support us. Also, please watch our previous videos on various topics and build up your knowledge. So without further delay, let's start with today's topic, writs. The first point, the orders issued by the Supreme Court or the High Court for the enforcement of fundamental rights are known as writs. So this is a definition for writs. The next point, the concept of writs were taken from Britain. Only the Supreme Court and High Court have powers to issue writs. The Supreme Court issues writs under the Article of 32, while High Court issues writs under the Article of 226. Supreme Court has the power to issue writs only for the purpose of enforcement of fundamental rights, while a High Court can issue writs not only for the purpose of enforcement of fundamental rights but also non-fundamental rights. Supreme Court can issue a writ against any person or government within the territory of India, while High Court can issue a writ against a person, government or any other authority only if they are located within the territorial jurisdiction of High Court. There are 5 types of writs. So the first one is Habeas Corpus, second one is Prohibition, third one is Mandamus, the fourth one is Quo Warranto, and the last one is Certiari. So we will be discussing each of these writs in detail. The first one is Habeas Corpus. Habeas Corpus is originated from Latin and it means to have the body or to produce the body. So the meaning of habeas corpus is have the body or to produce the body. It is issued by the court to call upon the person who has detained or kept another person in prison or in private custody in order to let the court know on what ground the detained person has been confined and to set him free if there is no legal justification for imprisonment. So that is the definition of habeas corpus. The habeas corpus is known as protector of a personal freedom or is also called as bulwark of individual liberty against arbitrary detention. So the habeas corpus writ is for the protection of personal or individual freedom. The next one is Prohibition Rate. The prohibition means to forbid or to stop. It is an order issued by the Supreme Court or any High Court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction. That is, this writ is issued when a lower court or tribunal tries to go beyond the limit of the powers vested in it. So that is the definition for Prohibition Writ. Prohibition writ can be issued only against judicial and quasi-judicial authorities. So the next writ is Mandamus. Mandamus means we command. It is an order issued by the court to a public official asking him to perform his duties which they have failed or refused to perform. So that is the definition for Mandamus writ. And due to this, Mandamus is called a wakening call and it awakes the sleeping authorities to perform their duty. It can be issued against a public body, a corporation, an inferior court, a tribunal or government for the same purpose. This writ cannot be issued against the President or the government of a state or against a working Chief Justice. So mandamus writ cannot be initiated against President, Governor and a working Chief Justice. This writ cannot be issued to a private individual except where the state is in collusion with the private party for contravening a provision of the Constitution. The next writ is quo warranto. Quo warranto means by what authority or by what warrant. It is issued with a view of restraining a person from holding a public office to which he is not entitled or qualified. This writ is applicable to the public offices only and not to the private officers. So quo warranto writ is applicable only to the public officers and not to the private officers. And the last one, certiorari. Certiorari means to be certified or to be informed. It is an order issued by the Supreme Court or any high court to a lower court or a tribunal for quashing the order already passed by an inferior court, tribunal or quasi-judicial authority. So that is the definition for certiorari. It is also issued by a higher court to a lower court or tribunal to transfer a case pending with the letter to itself. And the last point, certiorari is both preventive as well as curative, unlike prohibition, and prohibition is only preventive. So prohibition writ is a preventive in nature and certiorari is both preventive and curative in nature. So friends, these are the important points regarding the writs in Indian Constitution. So that's it for today. So if you feel that this video was informative and useful, please like it. Also, please subscribe our channel and press the bell icon so that you will get the notification for all the new videos which will be uploaded in this channel. I will meet you again with another informative video. Thank you for watching and have a good day.